And then a motion to revoke probation was filed alleging, among other things, that the defendant committed the offense of theft of property on or about December 10th. And it looks like he was caught stealing from Dillard's. Is that right?
That's correct.
And when you were released, you report responsibly and follow all the rules. You run out of chances now. Start living honestly. Can you do that?
In the pursuit of truth, we analyze the law. This is Justice Clash 24.
This sovereign citizen was already on probation, then got caught stealing again.
24 CR 889 is called You or Darwin Alvin James McMillan. Present with Mr. Dusler, your attorney, and the state's attorney. There is a motion to revoke probation. Earlier, you had pleaded true a couple of weeks ago or so, 10 days or so, to committing the offense of theft. And you're on the second-degree felony of burglary of a habitation. It's regular probation, sentenced to 10 years in prison, probated for 10 years. And we reset this to continue this hearing on this day. And what's our plan?
The plan was that he was to pay the balance of restitution, which is $350.
Was that done?
Yes, sir.
Okay.
And then you were going to hopefully favorably consider reinstating on probation if he did what he was supposed to, that you asked about paying the restitution.
There wasn't an agreement to that, Judge. As my notes reflect that the state had asked for 5 years TDC. He, of course, you understand, is requesting that, but there wasn't an agreement in that regard.
That's correct. There is no agreement.
How much time does he have for this? May I see the please? I don't even get to say the whole word. Or you do something.
Yeah.
It's an accident, Judge. It's not going to happen again.
You know, you're way ahead of us now.
Well,
I'm sorry, how much?
I'm calculating.
Whatever happened to Dewan, his brother, on this?
I don't know that answer, Judge.
Okay.
I'm picking this file up from somebody else's caseload, so I don't know.
Yeah, I think I see what I need to see. Thank you on that.
Good Judge.
All right. I think I understand what you're here. The defendant was placed on probation, regular probation, for the second-degree felony of burglary of a habitation, where it is alleged he intentionally and knowingly entered a home habitation without the effective consent of the owner with the intent to commit theft, and was placed on regular probation for that for 10 years. And then a motion to revoke probation was filed alleging, among other things, that the defendant committed the offense of theft of property on or about December 10th. And it looks like he was caught stealing from Dillard's. Is that right?
That's correct.
And they've been on probation for about a year and a half. And I'm looking at 231. Nope, that's not in.
No, he's got this.
It's 5.
How much? 55 days.
Okay.
Just beginning. All right. The state is asking for revocation, I guess.
Yes, sir.
What's the defense say?
Well, you were concerned about the initial restitution of $1,000.
Yeah.
That's the reason
I'm
he got
always
reset.
concerned
He
about
did what you asked him to do. He raised $1,000 and has paid that in full. And he realized that he made a stupid mistake doing shoplifting. Realized he should not do that, but he's looking at up to 10 years in prison. But he's asking the court to favorably, since he did what you asked him to do, to consider reinstating him on probation, keeping him on regular probation, see if he can complete it successfully. Right.
What is it about stealing that gives you a problem of following the rules over? What is it about stealing that get you in trouble. Thou shalt not steal, that's a rule.
Stupid decision, I learned my lesson.
I thought you learned your lesson when we put you on probation the first time for stealing, burglary with intent to steal. That's looking at 20 years. All right. Anything else?
No, sir.
Okay. Yes.
Judge, I think you know what my position
I know.
is. He's on probation. He commits a new offense, and
This theft is what degree crime?
it's a misdemeanor
It's a
offense, Judge.
misdemeanor. It looks like it's above 100, but less than 750. Was that Class B?
Class B, you're on.
Okay. All right. I'm going to find that there is sufficient evidence supporting this motion to revoke probation to grant it by a preponderance of the evidence or greater, as you have pleaded true to allegation 1, committing the offense of theft voluntarily, knowingly, intelligently, and you admitted that you did that. You pleaded true because it was indeed true. That now I can revoke your probation and sentence you up to 10 years in prison. Here's what I'm going to do. It's Class B misdemeanor. I don't know if they filed something on the side on that, but you know better. You're going to pay a price. Even though I can revoke your probation, I'm going to continue your probation, but you're going to stay in jail for 3 months. You won't be stealing, at least in 3 months, but even a misdemeanor theft has a price, and you're looking at 10 years in prison. So I'm going to modify the conditions of probation to add 90 days jail confinement.
He was given a second chance for a serious felony, but instead of learning, he committed another theft. The court had the power to send him to prison for years, and everyone expected the worst.
When you are released, you report responsibly and follow all the rules. You run out of chances now. Start living honestly. Can you do that?
I think Your Honor, the
Yeah.
probation officer had a suggestion
Is there anything else we want to add as conditions of probation?
She wants to keep him, Judge. I just wanted to make sure she was heard, Your Honor.
Okay.
Thank you, Judge.
Live honestly. Okay. Anything else?
No.
That is all. Thank you. Cases are called the State of Texas versus Stephanie Rochelle Martin. Cause numbers 25-1071, and that is alleging a state jail felony of theft.
Both of the pleas
Vince.
are enhanced to a third degree.
1072 will be dismissed as part of this agreement. That's a theft of property. And then 25 CR 1073 is fraudulent use or possession of identifying information. State jail felony with a bunch of tires. Okay. Let's take these up in numerical sequence with beginning 25 CR 1071. In each of these cases, you are Stephanie Rochelle Martin. Right here with Mr. Kimber, your attorney and the state's attorney. Does the defendant waive formal readings of these indictments and arraignments? Can we proceed in some?
She does, and we may.
All right. In 1071, this alleges in paragraph 1 that on or about November 11th, 2024 in Jefferson County, Texas, you committed the state jail felony of theft. And it goes on to allege, among other things, this is state. Okay. Indictment 1, paragraph 1 is theft of less than $2,500. To make it a state jail felony, there needs to be 2 or more prior convictions out of paragraph 2 of thefts. Correct, everybody?
Yes.
All right, and which ones are we alleging? Does it matter? Is it 1 and 2 out of
She has
county?
multiple, here.
Yeah, out of county courts,
Multiple misdemeanors.
law of 2 and 3. Paragraph 2 goes on to allege, ma'am, that on August 14th, 2001, out of County Court at Law 2 of Jefferson County, Texas, in 223744, you were convicted of the offense of theft. And the paragraph 2 goes on to allege that on March 15th, 2006, out of County Court at Law 3 of Jefferson County, in cause number 252495, you were convicted of another offense of theft. So paragraphs 1 and 2, if those two items are true, constitute a state jail felony. However, paragraphs 3, 4, and 5 allege that you were convicted of 2 or more state jail felonies of illegal possessions of a controlled substance in paragraphs 3 and 4. And I believe this becomes a state jail felony, though punished as though it were a third-degree felony by paragraphs 3 and 4. Am I right, everybody?
The 2 state jail convictions enhance the enhanced state jail.
So do you understand what you're charged with here, man?
Yes, sir.
This becomes a state jail felony, though punished as though it were a third-degree felony.
Right.
What starts out as a misdemeanor, it's published as a punished as a third degree. It's a 2-step enhancement.
Well, at the end of the day, it's
It's third degree.
It's punishable as a third degree.
Punishable as a third. I don't think it doesn't function as a TDC.
no, hold on.
It doesn't function as a TDC.
This becomes, in paragraphs 1, 2, and 3, as we discussed, a state jail felony, though punished as though it were a third-degree felony. So it will be a state jail felony on the books, but it's punished as though it were a third-degree felony because of the prior felony state jail convictions that are alleged in paragraphs 3 and 4.
It's not a TDC conviction.
It's a state jail felony, but you're punished as though it were a third-degree felony. So you're facing a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Awesome.
And there's an agreement that's further been reached where you would be sentenced to 5 years in prison. I think that's a 5, isn't it? Is that a 5 or a 6?
That's a
Five.
That looks, yeah.
Actually,
We
it's a
gotta fix that. Everybody, right? We're writing fast here, and these numbers sometimes.
It's 5. You know.
I wrote the Arabic 5.
Thank you.
Uh,
I wrote the Klingon for
this agreement is that you would be sentenced to 5 years in prison to run concurrently with the second case you're going to be pleading guilty to, and a third case will be dismissed.
Yes, sir.
Is this your understanding of the plan?
Yes, sir.
And also, Your Honor, states agreed not to file a pending state jail possession case.
Yes, Judge.
If I follow, okay. Yeah. If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
So how do you plead to allegation 1
Yes.
here?
Oh,
Hold on.
sorry.
How do you plead to allegation 1, which alleges that on or about November 11th, 2024 in Jefferson County, Texas, you committed theft? Guilty or not guilty?
Yes, sir.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
And then paragraph 2, the allegations 2 of these prior county court of law numbers 2 and 3 convictions in cause numbers 223744 and 252495, which are alleged in parts 1 and 2 of paragraph 2 of this indictment. Are those prior convictions true and correct as they are alleged?
Yes, sir.
And are you pleading true and correct that voluntarily and because those allegations are indeed true of those prior
Yes,
convictions.
sir.
So that makes paragraphs 1 and 2 a state jail felony. But we go further. Paragraphs 3 and 4 allege that paragraph 3 states that on August 24th, 2015, in this criminal district court of Jefferson County, Texas, you were convicted in cause number 1523034 of the state jail felony of possession of a controlled substance. Is that true and correct as it is alleged?
Yes, sir.
And are you pleading true and correct to that voluntarily and because it is true?
Yes, sir.
And the next paragraph 4 goes on to state that you were also finally convicted on April 11th, 2016 of illegal possession of a controlled substance, a state jail felony in this criminal district court of Jefferson County, Texas, in cause number 15-23446. Is that true and correct as it is alleged?
Yes, sir.
And are you pleading true and correct to that voluntarily and because it is true?
Yes, sir.
This constitutes then paragraphs 1 and the 2 portions of paragraph 2 of prior convictions that you're pleading true to, and paragraphs 3 and 4 of this indictment constitute a state jail felony, though punished as though it were a third-degree felony. And again, you're facing not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
And the agreement, again, is reached that you would be pleading guilty, sentenced to 5 years in prison to run concurrently with this next case. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
So finally, how do you plead to paragraph 1 of this indictment charging you with theft, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
Just to be clear, Your Honor, she's currently serving out a 7-year sentence in plain state law. It's our intent that this run concurrently with the case she's already serving a 7-year sentence in as well.
And in paragraph 2, these prior convictions out of county courts of law that you've pleaded true to, are you pleading true voluntarily and because those are true as they are alleged?
Yes, sir.
And finally, paragraphs 3 and 4, those prior convictions in this criminal district court of state jail felonies of illegal possession of controlled substances, are those true and correct as they are alleged? And are you
Yes, sir.
pleading true and correct to that voluntarily and because those are true?
Yes.
I find, if nothing further, that the defendant has entered pleas of guilty and true respectively to paragraphs 1, 2, 3, and 4, which constitute a state jail felony, punished as though it were a third-degree felony. She's mentally competent to do so. She understands and appreciates the consequences of pleading guilty. There's sufficient evidence supporting the guilty pleas and pleas of true to find her guilty of this state jail felony, punished as a third-degree felony. And I find her guilty beyond a reasonable doubt of this state jail felony, punished as a third-degree felony. I'm following this agreement. The defendant is hereby sentenced to confinement for a period of 5 years based upon the agreement of this state jail felony, punished though as though it were a third-degree felony for the enhancements. So do you understand what has happened on this case, ma'am?
Yes, sir.
All right, let's go to 1073. And again, does the defendant make formal readings of these indictments and arraignments? Can we proceed to summon?
She does, we know, Your Honor.
In 25 CR 1073, ma'am, this indictment alleges that on or about January 14th, 2025 in Jefferson County, Texas, you committed the state jail felony of fraudulent use or possession of identifying information of less than 5 items. And this is a state jail felony. I think, yeah, I see what happened here. Okay, it's a little different worded, but we'll go paragraphs 2 and 3. We don't need 2 paragraphs to make a state jail felony here. So a fraudulent use or possession of identifying information is a state jail felony on its own, and it is involves, if convicted, no less than 180 days up to 2 years in the state jail, and a fine up to $10,000 can be assessed. Do you understand?
Yes, sir.
Paragraphs 2 and 3, though, go on to allege that you have been convicted of 2 state jail felonies, and paragraph 2 states on August 24th, 2015, in cause number 15-21530 in this criminal district court, you were convicted of the state jail felony of theft. And in paragraph 3, it goes on to allege that on August 24th, 2015, in this criminal district court of Jefferson County, Texas, in cause number 15-23034, you were convicted of the state jail felony of illegal possession of a controlled substance. Do you understand what you're charged with there?
Yes, sir.
Are those allegations all true and correct?
Yes, sir.
Then you were looking at a state jail felony, punished, though, as a third-degree felony, just like in the previous case. So ultimately, you were looking at a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached in your case here that you would be pleading guilty of the state jail felony, punished as a third-degree felony, and sentenced to a period of 5 years in prison, which would run concurrently with the previous case. And again, one case will be dismissed, 1072. Is that your understanding of the plan?
In addition, Your Honor, this case as well is agreed to run it concurrently with the 7-year sentence she's already serving.
Do you understand that?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
So how do you plead in this indictment in paragraph 1, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes.
Paragraphs 2 and 3, those prior convictions of state jail felonies of illegal possession of controlled substance, are those allegations true and correct as they are alleged?
Yes, sir.
And are you pleading true and correct to that voluntarily and because those allegations are true?
Yes, sir.
I tell you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it? Discuss it with your attorney? Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence without objection admitted. Among other things, this states you were mentally competent to enter your guilty plea, and pleas are true. These are freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You're giving up your rights to a jury trial and the rights to appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, sir.
State's Exhibit 1, part of the record for all purposes. Pre-sentence report is waived.
So
Nothing further. I'm going to follow this agreement and find you are pleading guilty to paragraphs 1 and true to paragraphs 2 and 3, which constitute a state jail felony punished as though it were a third-degree felony. You were making these pleas voluntarily, knowingly, intelligently in this indictment. You are, there is sufficient evidence from State's Exhibit 1 supporting your guilty plea to find you guilty beyond a reasonable doubt of this state jail felony punished as a third-degree felony. I now find you guilty beyond a reasonable doubt of this state jail felony punished as a third-degree felony. I'm following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years. These sentences shall run concurrently with each other. One other case, 1072, will be dismissed as part of this agreement. Do you understand what has happened today, man?
Yes, sir.
Anything else to add?
we rest.
Think I'm hoarse? Okay, that is all. Thank you.
Okay, good luck to you.
For more real courtroom breakdowns, subscribe now, because second chances don't last forever. One bad decision can cost you everything, and this moment proves it clearly.